Okay. Hi, this is Laura Pinn, the moderator speaking. Thank you so very much for joining us tonight. I also want to thank the Laurier Centre for the Study of Canada, Waterloo Region Community Legal Services, and the Unsheltered campaign at SDC for their support of the event. As we get started, I want to acknowledge that Waterloo Region is located on the traditional territory of the Neutral, Anishinaabe, and Haudenosaunee peoples, and the Haldimand Tract, treaty territory of 6 nations of the Grand River. Often we treat homelessness as an aberration from the norm here in Canada, yet Canada was founded on the displacement of Indigenous peoples from their homelands. The ongoing legacy of settler colonialism in Canada means that Indigenous peoples are more likely to experience unsheltered homelessness than other groups in Canada. Personally, as a settler, I think about this a lot in relation to how our responses to homelessness relate to our treaty and other obligations to Indigenous peoples. And so as we're getting started, I want to invite you to take a moment to think about your relationships to land and how those connect to the topic at hand from wherever you're joining the conversation tonight. Thank you so very much to everyone in attendance for making the time to be here. We'll be taking questions in the Q&A box of Zoom throughout the panel. Feel free to type questions there, and we'll try and get to some of them during a Q&A session at the end of the panel. If you have issues using the chat box, you can if you have issues using the chat box, put your issue in the chat box, which might not be the most helpful thing. But if you're able to, if you're having issues, you can put something in the chat, and one of our moderators here tonight will try and help you sort that out. So we're here tonight to discuss human rights, housing, and encampments, and how these issues came together in the region of Waterloo, specifically in relation to a court ruling at 100 Victoria Street North. In July 2022, the region of Waterloo filed an application with the Superior Court of Justice to evict encampment residents living at 100 Victoria Street North, a municipally owned lot. And they argued they were breaking local bylaws prohibiting the erection of tents and other temporary structures in public spaces. As you probably know if you're here, this case was heard in the fall of 2022 with arguments between the region's lawyers and Waterloo Region Community Legal Services, which was representing some of the residents living at the encampment at 100 Victoria Street. On January 27th, this past year, in the first ruling of its kind in Ontario, the Ontario Superior Court of Justice found that the region of Waterloo's attempt to evict encampment residents at 100 Victoria Street North was a violation of charter rights. And this ruling is likely to have significant impacts on human rights jurisprudence in Canada. So I'm so very honored to be here tonight to facilitate a conversation among legal, community, and academic experts. And I'm going to introduce each of the panelists, and I'll invite them to turn on their camera if they're comfortable doing so and say hello as I introduce them and their relationship to the case. We have Shannon Down, the Executive Director of Waterloo Region Community Legal Services, and Ashley Skaitema, the staff lawyer at Waterloo Region Community Legal Services. And Ashley and Shannon were the lead lawyers representing the encampment residents in this case.
Hi, Laura.
Hi, thanks so much for being here.
Thanks.
We have Dr. Erin Day, an assistant professor of criminology at Wilfrid Laurier University, as well as a leading scholar on homelessness in Canada. Hi, Erin. I'm so pleased that we're joined tonight by Jen Draper, a named respondent in this case, represented by Waterloo Region Community Legal Services. Hi, Jen.
Hi, good evening, everyone.
We're also joined by Charlie, winner of Waterloo Region's 2022 Kindred Spirit Award and a member of the Unsheltered campaign. Hi, Char.
Hi, Laura.
And Leslie Crompton was supposed to be here. Leslie's a member of the Unsheltered campaign, as well as was a witness in this case. Unfortunately, she was unable to make it tonight. As I mentioned, my name's Laura Pinn. I'm an assistant professor of political science at Wilfrid Laurier University. And like Leslie, I also served as a witness in this case. So let's jump right in. So I want to start by asking Jen specifically, if you can tell me a little bit about the history of 100 Victoria and how people came to live there.
Sure. So my partner Will and I, we were at Mary's place, well, on and off. We started there a year before in May. So the prior May, and then go back a year. We were actually the last couple taken into the couples program at Mary's. And then it was like they made excuses, like it was one couple a week until we were all gone. So at that point, like at this point we had come to December, and I was still staying at Mary's, and Will was staying at the overnights, but he's a lab sleeper. So there was some fear that some danger was coming his way. So he was sitting outside like all night in a sleeping bag, and I was like, this isn't going to work. So we collected tents and tarps, and we went down just behind the soup kitchen. I don't know if you know where the bunkies are. There's two little, they're like storage containers that they turn into tiny homes almost. Behind the soup kitchen, we were on the other side of those. But then with the soup having their permits in to add the third floor to the building, they were worried that our being there would jeopardize the permits, because it was December. We were having fires to stay warm, and they weren't sure we were far enough from the building. So they met with the region actually, and the owner of the secondhand store, and they all decided collectively that we should go across the street. We set up there the first day of winter last year. So the year before last, so 21. It was just us mostly. There were 4 tents all winter until March, and then one morning we walked out and there was like 19 tents. It just exploded.
So Jen, you and Will started to live there in December 2021, and then in the spring, the number of tents started to increase. And I think at the peak, there were 50 or 60 structures, maybe more actually, in that location. Shannon, go ahead, Jen.
Sorry, I think we were up to 167 people at one point.
Wow. Shannon, I'm wondering if you can tell us a little bit about how you came to represent some residents through Waterloo Community Legal Services in court.
Sure. So we had been working with some of the residents at the encampment prior to the region filing the application with Superior Court. We have on our staff some social workers who had been attending at the encampment and helping people with tasks like getting ODSP applications filed, referrals to other services, ID, helping people get filed documents to get their ID, things like that, tax returns. So we were familiar with the encampment and some of the people working there. The region actually reached out to us when they knew they were going to be filing an application and let us know. We at that point decided that we were going to represent people if people at the encampment wanted our help with the responding to the eviction application. So we did some prior to the application being filed, we also did some delegations to regional council asking for council not to proceed with an eviction. And we organized and facilitated some of the people from the encampment also delegating to council.
Thanks for that, Shannon. And so I think that's important that there was a whole process leading up to this, including some community members, community organizations calling for an eviction not to proceed. And I think it's an important moment to sort of step back and consider the broader context in which this court case is occurring. And for that, I want to ask Shar, if you could tell us a little bit about why, what's going on with homelessness in Waterloo Region, why folks are living in encampments in Waterloo Region.
Okay, so my opinion from what I've heard my opinion for what I've heard as well as seen myself is that a lot of folks are afraid to go to shelters because of the drug usage. They don't want to relapse if they're coming clean. They don't want their stuff stolen. They're not allowed pets. There's so many reasons why they don't want to go. It's just not safe. Like, they're not safe. They can't bring their, like, if they're a couple, they can't stay together. It's just, there's so many, like, I understand there has to be rules, but there's too many rules, right? But then there's not enough proper rules to keep everybody safe. So,
Yeah. And so sometimes in my work, I talk about push and pull factors, that there are factors that push people kind of either out of housing or out of the shelter system and towards encampments. And some of those push factors, senses of safety in shelters, which makes sense because, you know, especially in the context of COVID, shelters are a congregate living space where you share your sleeping space with a bunch of strangers whom you don't know. And then, you know, another piece I think in Waterloo region that's important is we've seen a dramatic increase in the number of homeless individuals, you know, people experiencing homelessness in the region over the past 5 years. And maybe Erin, if it's okay, I want to ask you to come in here and talk a little bit about sort of how these trends that we're seeing in Waterloo region relate to the broader context in Canada around housing and homelessness right now.
Yeah, absolutely. Because what we're seeing happen in Waterloo region is not unique to the region itself. We're seeing cities all across Canada experience the homelessness crisis, and I don't use the word crisis lightly here. The crisis that we're experiencing, and really it is a testament to 30 years of policy decisions that has created the crisis that we have today. And so we didn't always have homelessness to the extent that we have it now, in terms of the number of people, the diversity and the kinds of people experiencing homelessness. In my lifetime, right, in the 80s and the 90s. And so it was decisions made at the federal and provincial and to a certain extent the municipal levels, especially in the 1990s, when so many governments pulled away and said, you know, it's not our job to pay for social housing, to invest in housing, to invest in people. There was a clawing back of social supports and really that social safety net for people to be able to support themselves. And what we're seeing now and what people are living are the consequences of those 30 years of policy decisions. And speaking to what Shar was just getting at, part of the reason why I think we are in this sort of crisis that we're in now is pre-1990s, just the level of homelessness, the number of people experiencing homelessness was not nearly what we have today. And so this emergency shelter system was designed to address people who were in an emergency, a very small number of people who were experiencing a crisis of some kind. And when homelessness ballooned in the 1990s, the only tools that we had at our disposal were these emergency shelter systems that were never designed for people to stay in for as long as they've stayed in, for the number of people to be in a homeless shelter. And so it's only in the last 5 to 10 years that people have been able to take a step back and go, wait a second, what are we doing? We have used, because we were in crisis mode, we have used this system that was never designed for this purpose as an interim, as a Band-Aid solution to the crisis that we're experiencing now. And so now is the time to reflect and say, how can we do things differently? Because this emergency model isn't working, isn't adequate to respond to the homelessness we're seeing today.
Mm-hmm. Yeah. And so we've got really, deep roots in terms of thinking about, we have a crisis of not just housing affordability, but affordable housing right now, where there are not affordable housing options for people. And we've got that situation. We have declines in elements of the social welfare state. So aspects of, social assistance and things like that help contribute to keeping folks housed. And we have an emergency shelter system that's, I think it's fair to say overburdened right now. So not able to accommodate all the people without housing that might seek to access it. And then as Shar pointed out, even, when there are spaces, those spaces are not necessarily suited to folks. And I think we heard a little bit about that from you, Jen, as well, when you were talking about how you and Will had some difficulty finding a shelter space that could accommodate both of you. So
that's right. And actually, even scarier than that, is is between the ages, like up until 16, there's really no support at all. So I know there was some complaints about some children coming by the site and stuff, but between 13 and 16, they were on park benches because roof can't take them, shelters won't take them, like nobody would take them, right? So there's a lot of gaps, I find.
Yeah, thanks for that, Jen. I think, I think a lot of ways this case is about some of those gaps that exist and some of the obligations that different levels of government have to address those gaps. So I want to turn more directly to the case. I also want to remind the audience members that as you do have questions, you can pop them in the Q&A. And we are trying to reserve some time at the end of this to get to those questions. So I want to turn to Ashley now and ask, do you mind briefly walking us through the court case? As I mentioned in my introduction, there was a challenge to a Region of Waterloo municipal bylaw prohibiting the erecting of tents and other temporary shelters on public lands. And this challenge was on the basis of Section 7 and Section 15 of the Charter. What were the key issues at hand?
Thanks, Laura. So yes, as you mentioned, the region brought this application to court, and they were seeking the approval of an order from the court so they could essentially evict people that were living at this encampment. And in their materials, they also indicated that they were going to use this as a precedent to evict people that were living at any other encampments in the region. So in response, we alleged that the bylaw and the government actions were in violation of Section 7 and Section 15 of the Charter. So when we're talking about Section 7, this is the right to life, liberty, and security of the person. Life is really getting at the idea that state action shouldn't increase one's risk or chance of death. Liberty is talking about it's about human dignity, and it's about people's right to make fundamental personal decisions without state interference. And when we're talking about security of the person, that's about one's physical and psychological integrity. So that was the crux of Section 7. Section 15 is the equality provision in the Charter. And the arguments that we were making in the question we were asking the court to consider is, does the law have a disproportionately negative impact on certain people or certain groups? So I will talk later on about Section 7. But we were arguing essentially that the bylaw and the government action under Section 15, although it's neutral on its face, it would have a disproportionate impact, a negative impact on women and gender diverse people who are experiencing homelessness, and particularly people who are living at the encampment that have intersecting grounds of race and disability, and that an eviction would place them at a heightened risk of harassment and violence and abuse. Mm-hmm. An important element of the case was that amicus curiae was appointed. So this means someone was appointed to be a friend of the court, and they were appointed to advocate for the interests of people living at the encampment who either didn't have the capacity to instruct legal counsel, or their capacity was fluctuating or in question. And also the police service were involved as an interpreter, but they didn't actually take a position on the substance of the issues. So the very first issue that the court had to decide was whether or not the bylaw was unconstitutional, whether it violated Section 7 or Section 15 of the Charter. And the analysis that we were asking the court to look at was based on jurisprudence from British Columbia, which has developed a right to shelter. And so for about 15 years, courts in British Columbia have developed this jurisprudence, which essentially says that if there's a constitutional right to shelter oneself if the municipality doesn't have available or accessible shelter spaces. So those are the two main issues are really, what are the number of spaces that exist within the shelter system in comparison to the people in the region that are experiencing homelessness? And then really taking a hard look, like we're talking about now, a hard look at those spaces and whether those spaces are actually accessible and low barrier, and what that means for people that are living at encampments and if they can actually access those spaces. So we submitted a lot of evidence from encampment residents who talked about their own experiences within the shelter system, and also their experiences with living in comparison to living at the encampment and living at other encampments. We also submitted expert evidence from Dr. Sarita, who's a doctor who's been practicing in London for a number of years, and from academics who spoke about the risks of encampment evictions, and also the advantages and benefits of living in an encampment generally, and also in comparison to living in shelter. And so when it comes to looking at the accessibility piece, the issue we were asking the court to consider is whether or not folks actually can access those spaces that the municipality or the region may say exist. And so that's looking at issues, some of the things that have already been discussed, things like people living with partners, people who have pets, people who have disabilities or may have service restrictions at certain shelter spaces, if they can actually access those spaces, issues around substance users who may or may not feel comfortable with the rules or policies or inconsistencies in those practices within shelter, and also the issues around women and gender diverse people who may only have access to a co-ed space, who may not feel safe or comfortable accessing those spaces. That's the crux of like the Section 7 charter part of the case. The other issues that we asked the court to consider were around the risk assessment tool that the region had developed in May of 2022. This tool was something that the region used to justify its eviction. And so we had identified a number of problems with the risk assessment tool itself and a number of findings within the risk assessment tool that we were asking the court to consider. And then the other issue we were asking the court to consider is the encampment policy itself, which the region had developed in response to a previous encampment eviction. So this policy was developed in December of 2021. And we were asking the court to consider whether the region actually followed their own policy before moving to eviction, and whether there were obligations as a result of this policy on the region in terms of mitigating some of the risks that they had identified and some of the risks that they were using to say that they should be allowed to evict. So things like garbage, debris, rats. And so ultimately, we were saying if we're not successful in the charter arguments, we would ask the court to consider the encampment policy when it was looking at the municipal act injunction that the region was seeking. And we were asking the court to consider the fact that the region didn't follow their encampment policy as an exceptional circumstance not to grant, like this was in the alternative to the charter arguments. So lots of issues for the court to consider.
Thanks for that overview, Ashley. That's really helpful. So in a nutshell, there was the challenge on the basis of Section 7 and Section 15, and Section 7 in particular, building on arguments in British Columbia to look at whether or not, the right to take shelter, if there are not enough shelter spaces available, or if those shelter spaces are not actually accessible for people. And then, of course, other dimensions being the risk assessment tool. So I think a big part of the region's position was that the encampment is a risk, and we want to mitigate that risk by removing folks from it, as well as the region's own encampment policy, which puts forward a services first approach, at least as it's written, in terms of, eviction should be a last resort after we've tried to connect folks with services and so on. And so I think there's I want to raise this really explicitly, even though we've already talked about it, because I think that it's a common thread I see in public discourse around homelessness and encampments. And the judge in this case did reject the view, but many people believe that folks who are sheltering in encampments have other housing options, that they could simply seek shelter elsewhere. And so I think I'm going to sort of bring in Erin, Jen, and Shar into this. And I want to ask you, can you explain why this is not an accurate way of looking at it? That folks who are seeking shelter in encampments could just simply seek shelter elsewhere. There's other housing options. And I don't know if Erin, maybe if you're comfortable starting, or if Jen, if you want to start, I see you're unmuted. Yeah, Jen, why don't you start and I'll jump to Erin and then Shar.
Okay, well, in my particular case, when I became homeless, I pretty much lost my whole family. So in family, friends, anything like that, I didn't have those options. Some people can go couch surf for 1.5 years. I didn't have that opportunity. We were renting a room from a friend, and things turned sour, and he just decided, okay, I'm going to call the police. You need to get out. And because we were subletting, we didn't have any options. So the police were like, you just have to leave. So really, the shelter was our only option, and it wasn't an option. So really camp was it. And that's why the soup kitchen employees and the secondhand store employees met with the region to put us there because they knew we had nowhere else to go. And we had said to them at one point, if you're going to send us somewhere, make sure it's somewhere that we don't have to move. The beginning of COVID, like when we first became homeless, we spent 57 days waiting for our room to be available because they had a COVID lockdown in the shelter. So we were tired of moving the tent over and over again. So we specifically asked for somewhere we didn't have to move.
Thanks for that, Jen. And actually, Shar, I want to jump to you next. And I know you've done a lot of frontline work, like you've engaged with a lot of, you worked with a lot of folks who are experiencing homelessness, are sleeping rough. And so I feel like you've got a really great window into, some of the barriers for folks in terms of other forms of shelter.
Yeah. So when Victoria and Weaver first started, I was out there more. I haven't really been there recently, but I do other encampments. When they first started, we did get a big garbage bin to help them clean everything up. And the very next day, we got a nasty email from the region saying, that's not proper and you need to take that out. So the more we tried to like clean the place up and help them get everything organized, the more backlash we got. So that was another fight. I found that out a lot of encampments. I mean, 150 Main was the same. The more good we did, the more we got in trouble for it. I don't know. I feel like Mary's Place, yes, it's changed in the last 10 years, because I mean, that's how my road, I guess, started, was Mary's Place in 2011, 2012. I was there for a year and a half. And I mean, that place will make you, or it brings you down to the lowest place you could ever possibly imagine being, but it can also make you somebody that you never thought you'd ever become, either in both ways, negative and positive. I don't know. There's so much. It's really hard because as a frontline worker, I hear what we called them and nobody called us back for getting like Lutherwood, the working center. We hear that a lot, and I understand that everybody's busy, everybody's overwhelmed, but when they're getting removed off a housing list because they say that they haven't called, when they have, because you've been standing there and you've watched them make that call, and then arguing with the person, it's the same thing, like day in and day out. You see it over and over again, or it's always he said, she said with workers. Well, we didn't say that. When you're hearing the same thing from more than one person that live on the street, right? So that's a big gap as well. I don't know what else you want me to say, Erin.
That's great, Shar. I think you're pointing to some of the, the challenges. For example, to stay on housing lists, something that you have to call every month, right? And say that you want to stay. And that can be a challenging thing to do, even in the best of circumstances, let alone when you might have challenges in relation to phone access or computer access, right? Other challenges as well. Erin, I'm wondering if you can briefly build on what Jen and Shar have said to talk about some of the systemic issues in terms of folks experiencing unsheltered homelessness and an inability to access other types of shelter.
Yeah, I think Jen and Shar have done such a great job at pointing at the ways that we think that there's just so much available. And then when you actually try to implement it, and I've had this come over and over and over again as I've tried to just support people in a really informal way. You Google a list of services in your city and you're like, look, there's all these services available. And then when you actually try to access them, it's incredible, the barriers and the limitations to those things. And so when I really encourage people to think about why somebody is choosing to stay in an encampment. I haven't met anybody who's lived in an encampment who's taken that decision lightly. It really is about constrained choices and choices that people are making with very few options available. So we know that, in Waterloo region, for example, and I think Jen did such a great job at pointing this out, there are very few available spaces for young people, for women, for gender diverse people, for couples. And so even if there are you can quantify the number of beds available. It doesn't mean that those beds necessarily work for you. I also live in Cambridge, and there is, we talk about it a lot, right? That divide between people who want to stay in Cambridge, people who want to stay in Kitchener, and that ability to move around. And so I think it's important for us to keep in mind that people who are staying in encampments are doing so because it works for them in a way that shelters are not.
Mm-hmm. Jen, I thought I heard you say something. Did you want to jump in, or am I imagining that?
It's just funny. I had the same conversation with one of the 13-year-olds. I was like, stand here with me and take a look around. I'm like, there's not one person you're going to see that wants to be here. We're here because we have nowhere else to go, right? And I think she went home that night. So it was good. It was just reminiscent.
Yeah. I mean, as I look out my window right now, I see snow, and I really don't think, I think it's, again, I think it's, the issue really is access to appropriate housing. And encampments are not the best solution. However, they are sometimes what we have in terms of immediate shelter options for folks, but I'm getting ahead of myself right now. So
well, I think most of the people that ended up there in March were like in sleeping bags on the sidewalk. So really an encampment was a step up, really. At least they had help there with shelter and food, and then those kind of things, right?
Yeah. So I really wanted to sort of paint that picture of encampments is not about individual choice, but about systemic structural issues. Because I think, and I will say I'm not a lawyer, right? I'm an academic, but I do think that was something that was important in how the judge ruled in this case. And I want to actually invite Shannon to talk a little bit about the ruling, as well as some of the immediate consequences for the residents living at 100 Victoria. So what that meant for folks in that camp, and how did the judge rule on the different aspects of this case, and what did that mean for people who are living at 100 Victoria in the encampment there?
Yeah, and I think, as you said, Laura, the judge rejected the notion that people were choosing to live at the encampment when they had other viable alternatives. Like that was, he found that was not borne out by the evidence that was before the court. And I was really gratified that he really paid attention to the lived experience of the people who were the encampment residents. So their evidence went into court through affidavits, where they told the stories of why they ended up at the encampment, what their experience was using the shelter system, what their experience of living at the encampment was, and he looked at all of that and so he really focused in on the lived experiences to understand why people were there and what realistic alternatives they had. And he really, found that there were no realistic alternatives, that people were there because they had nowhere else to go. So that even though the region had in their evidence, shown that there were some, open beds, that on any given night, there's a certain number of beds that are available in the shelter system. The judge found that those beds were not necessarily accessible to the people who were living at the encampment or other people experiencing homelessness in the region. And that was sort of the bedrock for that finding, that the Section 7 charter rights of the people living at the encampment would be infringed by an eviction. And so that decision essentially was all we needed. We weren't successful in the Section 15 arguments, but ultimately all it took was that finding that the Section 7 charter rights were infringed to lead to the result that the eviction that the region was requesting was denied by the court. The court also found that the region hadn't followed their own encampment policy. It found that a lot of the risks that the region identified were either overblown or were risks that the region could have taken steps to mitigate, so that they had within their own power the ability to deal with a lot of the problems that they identified. So we saw there was a push-pull there, where the region was saying, well, the conditions at the encampment are dangerous. And they were providing some assistance, but, there was certainly a lot more that could have been done to reduce some of the risks that that the region had identified and that people were experiencing. And then I also think that the region downplayed some of the benefits, and that came through in some of our expert evidence. That people living at encampments actually do experience some benefits from living. It's not an ideal situation compared to, say, housing, permanent housing, but compared to being displaced and isolated in other encampments, which is what an eviction really does. It doesn't, when people are being evicted, it just means that they're subject to continued displacement. And that really increased, the expert evidence said that really increases the risk to those individuals. And the court accepted that evidence, which I think was also really key. So at the end of the day, the court ruled that the eviction could not take place, that there was a charter violation, and also that the region was not entitled to its permanent injunction that it was seeking because it hadn't followed its own encampment policy. And so what that means is that at the end of the day, that the people who are living at the encampment are not subject to an eviction order anymore.
Thanks for that, Shannon. So the judge did find that there were Section 7 violations, did not find that there were Section 15 violations, did find that the region did not follow their own encampment policy. Did I miss anything? Those are the key points, I think.
Yeah, and that the risk assessment was not, that there were problems, there were faults with the risk assessment, that some of the risks were certainly overblown, and other risks were risks that could have been mitigated by the region if they had taken appropriate actions.
Thank you. And I will say, as someone who studies, urban and local politics, I find the risk assessment piece very interesting. So it seems to me that there's an implication that there's some sort of obligation on the part of local governments to mitigate risk where they can. And so simply saying there are risks, even if those risks could be mitigated by the local government in different ways, is not a sufficient basis to say this is a dangerous situation. Our only option is to evict.
Right. And I'll just add one quick note is that one of the things that we argued at court was that the risk assessment, one of the things lacking in it was there was no consideration of the risk to the people at the encampment if an eviction were to proceed. So the risk assessment was all based on what are the risks to the community, what are the risks to the property, but not what are the risks to the people themselves who are living there and what would happen to them if they were displaced.
Yeah. That's such a great point. Thanks, Shannon. Jen, I want to ask you to jump in. Oh, Shard, sorry, do you want to jump in?
Yeah. Okay,
I'm going to get Shard to jump in, and then I'm going to get Jen to jump in. Go for it, Shard.
Okay. I find that really funny because, like, in the summer, like last summer, Aaron, Laura, and a few of people that I work with were part of the reason why 150 Main encampment started. And there was a lot of stuff that happened that week. And I found that so I ended up I had to call the police because there was not the police, sorry. I called the ambulance and the police showed up first because there was an overdose. And it was the dog that actually found him. He went into the walking path. There's like a bush there. And none of us knew he was there. The dog was acting all weird. So I went over to look and I actually found him there. And so we ended up getting in trouble because we called the ambulance. And it was the second time that day that we had to call 911 because there was a fire. And the fire wasn't even started from anybody from the encampment. It was somebody went past and flicked a cigarette. And it was like the wood chips. So it had went under a wood chip and was burning in ground. And it had went up into a tree and started the tree on fire from the inside of the tree. And it was burning like the whole day. And we were all there and none of us seen it. Mm-hmm. It was kind of cool to see something like that happen because you would never think about it. But on the other hand, we were like, what the heck, right? But they don't, like, they do SPDATs for people that go into like supportive housing and stuff. And those assessments I find very unfair as well, because some of the questions on those they're more triggering than helping. had to take them. I mean, I lived at supportive housing for a while. And I found every time I took one, I got depressed. Like I could have been in the best mood and then I had to take one. And I was like, you go in a downward spiral when you take them because they ask you questions that make no sense to housing. And so I understand what you were saying about the risk assessment because sometimes they make no sense at all. Sorry, that was my 2 cents worth. Just saying that there was a lot of risk at 150 Main, and there was a lot of people out there. And I mean, some of the risk didn't even cross our minds until they happened.
Yeah, thanks for that, Shar. Just for context for people who may not be familiar, 150 Main is a site where there's an encampment in Cambridge, which is part of Waterloo Region. And so there's just a couple of things I want to note from what Shar said, and then I'll turn to you, Jen. One is that part of the, so I think there is, we don't want anyone to be in immediate danger, an immediate severe danger to their life. So different municipalities have created and adopted risk assessment tools to try and understand how risky are different encampments, like when is there an immediate danger and a need to act. With the risk assessment tool that was previously in use by the region, something like calling an ambulance would count as a risky strike, right? It would be counted up the number of times emergency services were counted. So actually serves as a disincentive for folks to call emergency services because it can be used to create the argument that this encampment is risky. So I think that's important. And then just in terms of the SPDAT, for folks who aren't familiar, it's housing outreach workers use it as a way of assessing the severity of someone's experience of homelessness to try and triage. So I think this goes to the point that there's not enough emergency shelter spaces because we actually need to triage people using this tool to decide who's most in need of the spaces that are available. And the tool is very lengthy and some of the questions can be really re-traumatizing for folks. And so I think that also can be a disincentive to accessing the shelter system in terms of the need to go through that tool. So I do want to turn to Jen now and turn back a little bit towards the case and just ask, as a named respondent in the case and a person very directly impacted by the outcome of this ruling, what was your reaction?
I think we cried. It took me aback. I kind of milled over it though, like the poor judge, right? He was rocking a hard place. Either way, somebody's going to be angry at him, right? And you've got the region's painting this picture of how awful we are. Just we're spending $80,000 a month. I'm not sure what they expected the public's reaction to be, but we got a lot of backlash because of that. Them releasing like the amounts they were spending and inflating those, of course. The fight with the toilets and you know what I mean? They clearly didn't want us there. So they're looking for reasons to kind of to have excuses to get rid of us, right? So we most of the time they were at our site, they were there because somebody outside of the site had called them because there was a new car on the site, or I'm looking for my bike and I think it's over there. So they didn't get called much to help us. We did have some backlash from that, but yeah, we tried to keep things orderly as much as possible because we knew that was going to be an issue, right? When I was at Mary's, somebody stole my cell phone and I called them and they're like, what do you want us to do about it? And I'm like, you're the police, get my phone back, right? No, I think it's when you're homeless or you're like in a shelter, you're not paying taxes, they don't care much anymore to help you. So it's a struggle, right? You don't want to be there as it is, and then being told you can't be anywhere is kind of a big deal. And I can see like with the SPDAT bringing you down and then having to go like being there and having that. It's energy, right? You can almost feel it when people walk by, like that you're not wanted. So hopefully they do something to change that.
Mm-hmm. Can I ask, Jen, were you surprised? Were you surprised that you won?
A little bit, only because, like I said, he was in a rock and a hard place, and I was like, he's gonna retire after this case because he can't win. But I was a little bit surprised, not in Ashley's competence, but I did, like with our fire being so recent to the case. I have my own concerns, but with that coming up like so closely, right? I think it was only 3 or 4 days before the trial that our fire happened. It was huge. So that got brought up a bit. And I asked one of the volunteers one night, she said something about unsanitary conditions. And I said, why is that? I said, my parents pay $3,000 a year to have a trailer to go and do what we're doing. Right. And she's like, I never thought of that. And I'm like, most people don't think of that. Right. Like, as long as you're cleaning up after yourself and you're keeping things sanitary, what's the issue?
Mm-hmm. Yeah.
So, yeah, I was kind of surprised. Though, there's a different viewpoint from the general public than from the homeless people on what encampments look like from the outside.
Mm-hmm. Thanks for that, Jen. And I think you raise a really important point, which is stuff that we take for granted, like having the availability of sanitation services, right? Is super duper complicated if you're experiencing homelessness. I want to jump a little bit and talk about, I said, were you surprised that you won? And, I wonder also if Shannon and Ashley were surprised, though I won't directly ask you. You can tell me sometime. And I said we won, but of course, rulings are complicated. And we won is a big statement, right? And I know that something in this case was that the judge declined to find the bylaw prohibiting the erection of structures was a violation of Section 15, the equality rights section of the Charter. And I want to ask Ashley, if you can talk a little bit about the implications of that part of the ruling.
Yeah, sure. Thanks. Before I talk about that, I just wanted to say that something else we heard about, we heard a lot about the call center that people have to call into to try to access a space in the emergency shelter system, and about how that system itself is also not trauma informed, and like similar to the SPDAT tool is also very triggering for people, because you have to call and basically explain why you don't have anybody else to stay with, and go through how you don't have any family or anyone that you can couch surf with. So we heard that a lot. So that's another piece that's not necessarily accessible or trauma informed for people. So I just wanted to flag that. In terms of section,
it's called Here 24/7.
Okay, thanks, Shar. So for Section 15, yes, we lost on this argument. It's disappointing, but not actually that surprising. Section 15 is a provision in the Charter that I think lots of people have hope for, that can be this like incredible tool to move things forward. And unfortunately, the way that the jurisprudence has developed is just that's not been the case. It's a really, it's a hard test. It's constantly evolving. The Supreme Court is constantly making new pronouncements about Section 15. And in fact, like in the middle of our hearing, a new decision came down from the Supreme Court of Canada about Section 15. So I'll tell folks what Section 15 says. It states, this part of the Charter states that every individual is equal before and under the law, and everyone has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, religious, sex, age, or mental or physical disability. So we were arguing that the actions, the bylaw and the actions of the municipality had an adverse impact, and that it was adverse impact discrimination. So what that means is that if you take a look at the bylaw on its face, it looks like it's neutral. There's nothing directly discriminatory about the bylaw or the actions of the municipality in seeking this eviction, but it actually had a disproportionately negative impact on certain groups. And we focused our Section 15 arguments on women and gender diverse people that were living at the encampment, in particular because we had expert evidence from Dr. Caitlin Schwan, who was speaking about experiences of women experiencing homelessness in Canada. And we also had some really great local research from Project Willow, which had surveyed women and gender diverse people living in the region about their experiences of gender-based violence while they were being unhoused. And so that was our focus. And the amicus curiae, their focus around Section 15 was that the eviction would have a disproportionate impact on people who had mental health disabilities and who had substance use disorders. And so we had relied, our written argument, our factum was based on a case from the Supreme Court of Canada called Fraser, which basically the Supreme Court had said, you know, we've kind of been doing Section 15 wrong. It's supposed to be easier. We shouldn't be making it so hard for people to make these Section 15 claims. And it was an adverse impact case. So we based our arguments on that. We were very hopeful that maybe we would be successful on our Section 15 arguments. And like I said, in the middle of our hearing, this new decision came from the Supreme Court of Canada, which was called R.V. Sharma. And this case, there had been a switch in the makeup of the judges at the Supreme Court of Canada, and they sort of backpedaled a little bit on the previous case that we were trying to rely on. So the judge in our case rejected our Section 15 arguments. He didn't even really dive into the adverse impact analysis, which was a little bit disappointing. He essentially said and relied on some previous case law that said that homelessness is not an analogous ground that's protected under Section 15. So essentially being homeless is not a personal characteristic in the same way that like race is or your age is, for example. And so that's essentially what he used to reject our arguments. And like I said, it's disappointing, but not entirely surprising. And you know, still very happy with the Section 7 analysis that was given in this case.
Thanks for introducing that nuance, Ashley. I think it's important to talk about. I want to turn to Shannon now and actually just ask, so, you know, to sum up, and I think that, you know, I've seen a few questions in the Q&A that I've been asking along these lines. Why does this ruling matter? Why does it matter for, you know, housing advocates, for municipalities and service providers? Like, what's the significance of this decision?
I think the main significance kind of goes back to what Erin was talking about, is that we're in the midst of a housing crisis and a homelessness crisis right now. And so the issue of encampments is huge across the province, across the country. And this decision essentially provides will cause municipalities, I think, to pause and rethink their strategies when it comes to enforcement and evictions, and hopefully move more towards support and housing and seeking to provide actual adequate housing for people. So that's, I think, the main thing. I know that, you know, a lot of people have been talking, does this, you know, help with a right to housing? And it doesn't. It doesn't, there's nowhere in the decision where the judge finds that the people living in an encampment have a right to housing. It just says that they have a right to not be evicted from the tents that they're using for housing at this time. And so there's a pretty big difference there. And that, I mean, I think that's a reflection of sort of the state of Canadian courts, generally speaking, in that our court system is fairly conservative, and courts will often decline to rule on what they consider non-justiciable issues, which would be something like a right to housing. Those are really hard arguments to make in Canadian courts. And so obviously that would be like a pie in the sky goal to get a court to rule that. But I think, you know, if a lower court were to make a ruling in that nature, it would that would like be an automatic appeal. So we'd be looking at, you know, Court of Appeal and probably Supreme Court cases dealing with that issue. And that may happen. That may be, you know, there may be cases that make it up that far, that make that argument. But you know, I would say in the current climate of our court system right now, it seems like that would be a really hard battle to win. But I think this decision is a really good start. You know, it's maybe not the end point where we want to be, but it's a really good start for people to have a little bit more protection against municipalities displacing them from their, you know, the very minimal housing that they're fighting to maintain.
Mm-hmm. Thanks for that, Shannon. And it is the first case in Ontario yeah, I know it's building on jurisprudence in British Columbia, but it's the first case in Ontario where there's in relation to encampments where a Section 7 violation has been found. That's correct, right?
Yes, that's correct. So there have been other cases which have raised Section 7 in their arguments, but they haven't actually been heard on the merits. So there was a case in Toronto, the Black case. There's currently a case in Hamilton that's working its way through the court process right now. There's been a preliminary injunction stage. And so the issue of the charter, the Section 7 breaches has been raised before the courts, but not fully heard on the merits. So this is the first time it's been heard by court on the merits and then found that an eviction is an infringement of those Section 7 rights.
Thanks. I get very nervous when talking to lawyers. I'm like, I read the decision, and so I think I know that it found this, but I'm just going to double check with the legal experts that are here to make sure I'm not misspeaking in front of 100 people. I want to turn now to Erin and just ask, from your perspective as someone with deep knowledge of, housing, homelessness, and who does research in this area, how do you see the significance of this case?
Yeah, I think it's important to see this as a win. I think in our line of work and what we're dealing with, it's so hard to find wins sometimes. And so I really want to commend Jen and her peers that went to court to do this, and Shannon and Ashley that did all that hard work, because this is absolutely a win to have an Ontario case say this, to say that this is a violation of Section 7. At the same time, there's a couple of things I want to bring up. First is that this case was about, and I'm not a lawyer, but this case was about a bylaw. And so, it isn't like, okay, now every city in Ontario has to abide by that. It's about a Waterloo region bylaw. And so it actually has to go city by city by city if people wanted to seek a violation of the bylaws in their cities. That said, we now have precedent. We can now point to this case as a way of like, oh, you might want to address this differently, other cities, because chances are a court in your city would rule against that bylaw. So it would be nice, it would be expedient if this could just be like, okay, now all Ontario cities or all cities in Canada have to abide by that. And that's just not how that works. And the other thing I wanted to point to, and I think some people have chatted about this a little bit, is that, part of the ruling about Section 7 was that there aren't adequate sheltering spaces for people. And that is in terms of the number of shelter spaces available and the kinds, that they're accessible. And so to that right to housing point, it's the remedy to this from a municipal perspective is, let's provide enough shelter spaces, and let's provide the right kind of shelter spaces. And so we'll have to keep pushing for it to move the dial on the right to housing, because so many of the issues that Shar and Jenna brought up around the rules and around how so many of these shelter spaces don't work for them and others would be eliminated if it was somebody's own house. You don't have curfews in your own house. You don't have rules around who's allowed to be in your space in your own house or what you're allowed to do in your own house. And so that's the fight we're going to have to keep pushing for, is around housing, and not only these emergency responses like a shelter space.
Of course, because someone who's accessing a shelter space or someone who's couch surfing, they still don't have housing, right? And so it's, it is such a deep problem. Jen, I want to ask you, how do you see the significance of this case? And then after that, I'll move to a Q&A where I'll try and address some of the questions that we've got in the Q&A box. But yeah, Jen, how do you see the significance of this? How does it matter for you?
Well, from our perspective, like I said, we started our homeless journey, I guess you could say, with 56 days on the sidewalk waiting for a room that was empty. And we moved in that 56 days 47 times. Because when you don't have somewhere to go, you don't have anywhere to go. Like, even public is off limits to you. And I never understood that. I kept asking the officers who would show up and ask us to move. It's like, this is public space. We're public beings. Why can't we be in public? And they were just like, I don't know. People are complaining. So can you move somewhere else? And it just became like, that's what it's a win in that sense for me, is, we felt hopeless. Like you don't belong anywhere. Right. I know my family's just cast me out. My friends have all turned their back. No, you can't sleep on my couch. And now even my own region is saying, I can't be here. I don't belong. Right. So it can be really damaging, I feel like, to people and their psyche and their comfortability in their own skin, or in their regions, to kind of feel like they're unwanted, and despised. I mean, we had people driving by every night at 3 a.m. honking their horns and stuff. And it's an annoyance, yes, but people shouldn't have such a horrible viewpoint of homeless people. And like I said, when they're publishing all these numbers, and stuff like that, they're only perpetuating that bad stereotype. And I think in order to improve the situation, I think we need to work more towards changing that attitude. Especially with COVID, a lot of people lost their jobs and lost their housing through COVID. So we should focus more, I guess, on acceptance, and help. What if we just erected some campgrounds around the area and people could just go set up a tent if they didn't have somewhere to go? You know, it's cheap, it's free. We'll find some Nadines around to help them out, and away we go.
Yeah. Thanks for those powerful words, Jen. And for those joining from outside Waterloo Region, Nadine is Nadine Green at A Better Tent City. Don't know if Nadine's here, but she's a phenomenal community organizer and human being. I do want to turn we've got about 11 minutes left. I do want to turn to get to a few questions from the Q&A, and so I'll just say to the panelists to keep your responses brief insofar as that is possible. One of the questions is, what does this ruling mean for other encampments in Waterloo Region? And we know there are a number of other encampments in Waterloo Region. How does this ruling impact those encampments? Could there be eviction attempts at those encampments or not? Or, yeah, I don't know if Ashley or Shannon wants to answer this.
Yeah, sure. I can jump in on this one. I think that any other encampment in the region, it's safe to say that the region won't be moving towards eviction because of this decision. And I imagine that encampments that are located on the city of Kitchener, city of Waterloo, city of Cambridge will likely not be moving towards eviction as well, because of this decision. Because what essentially this fresh decision says that it's a violation of the charter and there's nowhere for people to go. And so until that is corrected and there's enough shelter spaces, or there's ideally homes for people to go to, and that those spaces that exist in the shelter system are accessible, you know, I think the region will not be evicting anyone here.
Thanks for that, Ashley. And yeah, I agree as well. And I will say the regions decided not to appeal this ruling, which they could have done. They could have appealed it. And so, you know, I do want to say, I think it's tricky when you have a legal process. There's obviously animosity between sides. But in terms of individual folks working at the region and on the staff side, I have a lot of respect for the work that they do. Anyways, that's my tidbit. I do want to ask a question that someone's asked that's near and dear to my heart, which is, why is it not a violation of Section 7 for governments to pass legislation that puts citizens in peril, specifically in terms of, I think this question is getting at, why don't we have a right to a basic income? So why is that not a Section 7 violation to have Ontario Works benefits at $800 a month when we know that that's not livable? And I'm wondering if anyone's comfortable sort of answering that question.
I think it goes back to what I was saying, that our court system is pretty conservative when it comes to pronouncements on substantive, typically the charter arguments are used more as a shield as opposed to a sword in terms of protecting people against harmful government action. And I know that programs, obviously I agree with you. I think that, you know, Ontario Works rates, ODSP rates are harmful government action, but courts typically have said that those are those are policy decisions that courts are not, it's not their purview to rule on those things, that's up for governments to decide. And so unless you can show specific harm, like under Section 7 or under Section 15 to in the equality sections, courts are going to be really reluctant to say that there's a positive right on the government to provide a higher level of benefits. So I don't know if that's, typically our courts are fairly conservative when it comes to those sorts of arguments.
Mm-hmm. Thanks for that, Shannon. And I will say, oh, go ahead, Jen.
Sorry. I
Please
think
do.
at this point with the cost of housing, like it's not even OW, it's not even services anymore. People on minimum wage can't afford a place without a roommate.
Yeah. Absolutely. And I think, go ahead.
Sorry, I think we let our housing costs get too far out of control and we didn't like rein them in time, I think.
Yeah, absolutely. I think it's an issue that, you know, it touches most of us directly or indirectly in some way. I will say as a political scientist, we know that, you know, social and economic rights were not included in the Charter of Rights and Freedoms. And that was a specific decision that was made by the architects of that constitutional document. And so to have something like a basic income, a social and economic right, you know, that's not explicitly in the charter. And as Shannon said, the courts have been really reluctant to go there in terms of rulings that see the charter more expansively in those ways. I want to ask, there's a question in the chat. I think it's an excellent question. And it's asking a little, if we could unpack a little bit what accessibility means in terms of shelter spaces. So does accessibility refer to the safety of shelter users? What does accessibility mean in terms of the judge finding that there were not sufficient accessible shelter spaces in the region for people experiencing homelessness? Jen, is this one you want to jump in on?
Just quickly, the first night that the emergency overnight opened across from Mary's place, a gentleman showed up with a dog and they turned him away, and it was a service dog. So stuff like that.
Like lack of pet-friendly facilities for people that need pets.
Well, that, and I mean, it was just like at their discretion, right? And I'm like, that's a service dog. Like, that's like telling me I can't take my glasses in. You know, I need my glasses to see, but I can't take them in. Like, I'm obviously I'm not going to go there, right? And he didn't. He sat outside all night with his dog because the dog wasn't allowed in. And it's just, that's what popped into my head with the question. Sorry.
Yeah, no, that's great. And even if I was calling a service dog a pet, I was like, that's not right, because it implies that it's something that's like voluntary, or you know, what
a family member.
Yeah. Shannon, I want to get you to jump in on this as well.
Yeah, so I think it's in the specific context of this case. I think the accessibility issue is sort of two things. What Jen is saying, so for any particular individual, like their characteristics when they're coming into like conflict, or they're clashing with the rules or the procedures or the policies of the shelter system, that creates an accessibility issue. And then it was also, you know, it's also around the issue that on any given night, when the region's system is showing X number of empty beds. So, you know, for example, the region had in their evidence that on any given night last summer, there were between 25 and 30 empty beds. When we drilled down into that evidence, it turned out that, you know, maybe 15 of those beds were COVID beds. So they were set aside specifically for people who were testing positive for COVID. And maybe another 10 of those beds were in the youth shelter system. So they're not accessible for anyone who's over the age of 25. So, you know, when you're looking at statistics, when governments have statistics about how many shelter spaces they have and how many empty beds they have, you have to keep in mind that for any given person who's seeking a shelter bed, there may not be a bed available on any given night that suits their needs, that they're actually permitted to use, right? So it's both could be their own personal like dignity and choices and characteristics, but it also could be the system says you cannot be here. So I think those two things.
Yeah, absolutely. And I saw a follow-up question in the chat asking about substance use, which I think is another complicated issue. So for some folks, you know, shelters may be a place where folks are using substances, and if they're attempting to abstain, that can be a really difficult environment. For some folks who need to use substances, being in shelters that have rules around substance use can be really difficult. And they're constantly having concern about breaking those rules, right, and being forced to leave. And so it's a very difficult thing. And there are not really, you know, I don't know of a lot in Waterloo region specifically of shelters that permit substance use, wet shelters. I don't know do you know of one, Shannon?
No, but yeah, I agree with you. I think there is no specific wet shelter, like where substance use is explicitly condoned. I don't believe. But But so inconsistent policies around shelter or around substance use or not allowing substance use is a problem, like you said. The other thing that I just wanted to quickly mention that I don't know if it's been brought up yet, but a lot of our clients had experienced service restrictions. So they may have been restricted from using a specific shelter because they were in conflict with the shelter or the rules at the shelter. And some of those service restrictions can last up to a year or longer. So you could have someone who's been banned from certain shelters for long periods of time, and that created a lot of accessibility issues as well.
Yeah. Thanks for that, Shannon. And I have seen that in some of my direct work with people experiencing housing precarity as well. I want to ask a question of Shar, and it's a tough question. I hope that's okay. What would you say, and then I'll sort of open it up if anyone else wants to weigh in. What would you say the next steps are for community organizers in light of this ruling, like the Get Sheltered campaign?
Just keeping on track of it, like keeping the region accountable for what they're saying that they're doing, because if nobody's watching them kind of and nobody's like calling them on stuff, they kind of like, okay, we're done, we're not doing it anymore. So you have to really, like, I think we have to all kind of keep on the region's case about stuff. I think that's big. And just, I mean, for frontline workers, keep your promises. You know, if you say you're going to do something for somebody out there, do it. You know, and if you aren't sure if you can do it, say, I'm going to do my best to do this for you. I will let you know either way, right? Like, stop giving them false hope. Yeah.
Mm-hmm.
It wasn't that hard of a question.
Oh, I thought it was a hard question. I was like, I'm really, as someone who, does some community organizing, I'm really chewing on that one. I will say, I do think as someone who does some community organizing and also does academic work, I think this ruling gives us another tool in sort of our arsenal to throw at the wall and see if it sticks. Like, also, there are we say over and over again that there are human rights considerations around how we respond to encampments. And now we have a judge who also agrees that there are human rights considerations. And so I think that's something that I can sort of take away from this and think about using in advocacy. Go ahead, Shar.
So as like a peer outreach worker, I find that my past helps me with it, because I lived at Mary's Place. I was homeless for a while. I lived in supportive housing. I had the whole great upbringing, LOL. So I've kind of been there, done that, right? And I mean, so when somebody says something, nobody's story is exactly the same, and you don't exactly know how somebody's feeling, but you closely do sometimes, right? Like, there's a lot of similarities. So I feel like because I had that experience, I understand more and I'm more compassionate about it. And I feel like a lot of people still know who I mean, come on, guys, you all know me, I'm loud, I'm out there, I talk to everybody. So I feel like because I am well known, because of my past, a lot of people that are living on the streets either know me or my brother. My brother's so innocent. I'm really not either, but I mean, I grew up and I got my feet back on the ground. It was hard. It took me a long time, but I'm still working on some stuff. So I feel like when they talk to me about stuff, I think there's a little more pressure, because they're like, come on, man, like, we know your brother, or like, come on, don't you remember when we used to do this? Yeah, I remember that, but I went this way and you stayed here, right?
It can
like
feel a little
I
patronizing, right?
Yeah. So like I think I recognize you, Jen. I don't know if you recognize me, but I think you know my brother as well. TK is my brother.
Oh yeah.
Yeah, my brother. Me and him are totally opposite, night and day.
Thankfully, he was there the morning of the fire. He got Will.
Yes, he was. So I mean, don't get me wrong. I love my brother and I'd do anything for him. And I get asked a lot, why don't you let your brother live at your house, right? And I'm like, because I have kids and my brother still uses, and my brother's an open, he'll say it. So I'm not like gossiping about my brother on this or anything, But it does weigh on me knowing that my brother is living in a tent somewhere. Well, right now he's in jail, but I can't let Terry stay here because I have a 5-year-old, and my 5-year-old is very curious, right? So, and Terry understands. I mean, I've helped him as much as I could. I mean, Terry lived with me for a long time before my kids came.
I was gonna say, you probably did that already before.
Yeah. It was me and Terry had a really rough upbringing. It doesn't mean I don't love him, and it doesn't mean that he can't call me or come into my work. He knows where I work. He knows where the office is, right? He makes his own choices, and he's an adult, so I can't hold his hand all the time anymore, even though I'm the big sister. I mean, come on, guys, everybody's bigger than me, so I mean, he has to learn to fight some of his battles on his own. But it's hard because people are like, "How are you staying out here offering to help me when your brother's struggling?" Well, my brother's choosing to struggle because he's not ready to say he has a problem, or he's not ready to admit that, there's stuff he could be doing. I don't know. I think Terry chooses that lifestyle, and that's another thing we face. A lot of people want to be there because everybody's like, oh, we need to end homelessness. But realistically, not everybody wants to be housed as well. Yeah. Right?
Hence the new hybrid shelter, right?
Yes.
Yeah, which is an initiative to have a hybrid outdoor-indoor shelter in Waterloo region that should be opening in the coming months. Yeah, I will say, I think some of this goes to really the complexity, right? The complexity in terms of, but I think, what the ruling gets at is that regardless of folks' individual situations, everyone deserves a shelter. I know we're over time. I do want to ask, if I can press upon people, those that are still able to be here, I do want to ask one more question. And that is, what recommendations would you give to municipal enforcement officers who are tasked with addressing concerns received from the public relating to the health and safety issues at encampments, such as unsafe burning practices and things like that, while also respecting the rights of encampment residents? And I maybe want to turn to Erin first, and then I'll ask if anyone else wants to jump in, because I know, Erin, you've done some research in this area.
Yeah, thank you. That's a great but tricky question. I'll keep it really short because we are over time. Really what it boils down to is municipal law enforcement is driven by complaints. And so as the public makes complaints, then bylaw is obligated to respond to those complaints. And so I think a lot of the work that needs to be done, and I've seen some bylaw officers doing this work, is trying to help some members of the public who are calling in those complaints, help them understand what the situation is. And so working on that end. And I also think that there are ways, this has come up, yeah, I'm going to be really careful here, but this has come up in the last little while about it's okay if people have concerns. It's okay if people aren't sure what it means to live close to an encampment and what that is. Where we want to work on this is how do we address some of those concerns, and how do we address those fears in a way that addresses those fears while maintaining the rights of people who are homeless, and act on solutions that will actually work. So some of the solutions that people say is, let's just, to Jen's point, let's just get them all out of here. Let's just kick everybody who's homeless out of the city. That's not realistic. That's not going to happen. So how do we work together so that everybody feels safe, encampment residents and their neighbors? I think there's a lot of opportunity for shared conversation and mutual understanding, because like, as Jen talked about, wanting to keep the encampment clean and organized, right? There is space for convergence. There's space for understanding where people actually are on the same page. And I think we just need to pull those out and reflect on those.
That's a really beautiful note, Erin. Thanks for that. The hope for convergence. I do want to ask Shannon and Ashley one final question, and then I promise we will end. And that is a question in the chat. Are we likely to continue? So is Ontario likely to continue following the track of jurisprudence from British Columbia around encampments, or are we likely to, in the word that the person used is backslide? Are we likely to backslide a bit? Like, is this going to stick? And I don't know, can you look into your legal crystal ball, your lawyers, so you know, right?
I mean, I can tell you that where we landed in Ontario is where BC is at the moment. So BC has been developing this case law for 15 years. And the judge could have gone with the 2008 version of these rights from British Columbia, but he came right up in line with where British Columbia is now. And I think that that's incredible. So I think it's unlike, if I'm going to gaze in my crystal ball, and Shannon, you can weigh in too. I think that we've landed in a really good place where we're in line with British Columbia jurisprudence, and I don't see it backsliding. But what do you think, Shannon?
Yeah, I think the decision is really well written. Well, the analysis is really thorough in the Section 7. And it really draws on a lot of the evidence that we put, forward to the court of the expert witnesses like Dr. Pinn, Dr. Sarita, and the lay evidence that we had. So I think that it serves, I think it's a great template. So if another court, didn't follow it, that's always possible, but I just feel like, I feel like Justice Valente did a very, very thorough job of going through the evidence and then analyzing it and applying the charter arguments to it. So I think it provides a really good template.
Thanks for that, Ashley and Shannon. There are so many good questions in the chat, just so many that I wish we could get to all of them. Some of them incredibly legal, and I don't know the answer, so I want to hear it. But unfortunately, we're a bit over time. So I just want to thank very sincere thank you to all of the panelists for being here. And I really deeply appreciate your time and your candor and, speaking to your expertise on this issue. Thank you so much. I do want to mention that there's a couple other events coming up if you're interested in housing or if you're interested in Waterloo Region. And maybe I'll ask if the Laurier Centre for the Study of Canada can just pop the slide with those details onto the screen. So the first one I'll mention is on March 16th at 7 p.m., Staking Our Claim, Charting a Path for Realizing the Right to Housing for Women and Gender Diverse People. This is a hybrid talk. You can attend remotely or in person. And Erin Day on this call is organizing it. Highly, highly recommend, especially if you want to get at some of the equity issues that we only scratched the surface on tonight. The second event I want to mention, which may be of interest to you if you're joining us from Waterloo Region, the A word is Amalgamation, the Future of Governance in Waterloo Region. And that is inconveniently at the same time. So you got to pick one. It's a Zoom event and it's, again, free to register. So please check it out. And the third event that I'll just note, which conveniently is it's on a different date. So you could go to one of the other ones and this one, Critical Histories of Blackness in Canada, R versus RDS. Featuring Dr. Barrington Walker from Wilfrid Laurier University. And this is also a hybrid event, either in person or online on March 22nd at 7 p.m. So do consider checking out some of these upcoming events. Again, huge thank you to our panelists for being here. Thank you to Waterloo Community Legal Services, the Unsheltered campaign at the Social Development Center, as well as the Wilfrid Laurier Centre for the Study of Canada for your assistance with organizing this event tonight.